This is a Zoom session for weeks 1 and 2 for Environmental Policy and Introduction to the Legal System for Laws 11046 Law and the Environment, presented by John Milburn. As a note, online sessions are recorded for educational purposes. Recording of Zoom may be uploaded and appear on YouTube and Moodle. If you have any concerns about being recorded, please turn off your video, camera or audio or both during the session. Your participation will signify your consent to the recording and publication for educational purposes. Sorry about that. Now, for those of you who have had an opportunity to look at the introductory video that I posted yesterday, you'll know something briefly about me and the process that I am keen to follow. As you would have seen in that commentary last night, and also in various commentaries that I've made, the way I intend to run this program this year is perhaps a little different to what previous students have experienced. There is a great deal of reference material available to you. I'm going to rely very heavily upon and follow the text, which is by Jerry Bates, Environmental Law in Australia. This is the 8th edition. For those of you who have it, you'll see how easy and informative it is, easy to read and informative it is. And for those of you who don't, you'll see how thick it is. There's a lot of reading to do there. So that's why I'm choosing to follow the text pretty closely. In Moodle, you would have seen the outline of headings. And this week's a pretty easy week. It's just an introduction to the legal system and environmental policy. And really, I'm just going to follow through on Chapter 1 of the Bates book. I take it that you all have Bates by now, or at least you've ordered it. Thank you. A little bit about myself by way of background. I am a lawyer. I'm in private practice. I was admitted in 1984. I did my studies at the University of Queensland in the mid to late 70s and then through the early 80s. I completed my undergraduate there at the University of Queensland with honours. I did my articles of clerkship with a firm that was then known as Cannon and Peterson. It went on to become Deakins, and now it's known as Norton Rose Fulbright. My practice is primarily in litigation, but I do have essentially 3 paid jobs. This is my 3rd job, which is as a course coordinator lecturer, if you like, for Central Queensland University. My 2nd job is I'm a member of the Queensland Civil and Administrative Tribunal, and in that regard we hear cases, I run conferences, conciliation conferences, etc. And just, it's not accessible, but if you're interested, I've posted a link to a couple of my published decisions which came out late last year for QCAT. I was originally a mentor tutor for the university, and I was privileged to be given this opportunity to have an ongoing role as course coordinator. Now, if I just stop there, I'm getting a little bit of feedback. Is everyone hearing me clearly enough? Just let me know if there's a problem. All right, well, I'll continue. Thank you. Apart from that, I did co-establish with Magistrate Guttridge, as he is now, the legal service in Harvey Bay, which is where I'm based. I'm nationally accredited as a mediator, and I was chair of the College Council at the Fraser Coast Anglican College during its early years in the 1990s, and I've been re-invited back onto the board or the council this year. So lots to do, and that's my background. As you would have seen, I'm very keen on communicating via email, and I invite you to send me emails throughout. I'm very keen also to communicate through the Moodle site. Lots of questions and answers. Sometimes if you raise a question in the general discussion, I won't jump in too quickly with my response because I'm very keen for you to start communicating with each other. And having progressed this far through the course, I'm sure that you're all used to doing that. I would be very happy to see you establish study groups, and I don't know where you're transmitting from, but it may be that through Moodle, in the general discussion area, I can encourage you to start talking to each other, maybe just posting where you are located geographically, maybe something of your interests, and maybe you could start creating some study groups to assist you through this course. Now, as I understand it, you are not law students per se, and you're studying this subject as part of an overall degree, presumably in accounting or business or something else. So that being the case, I will try to stop, explain legal concepts, explain the way it works, and certainly invite questions. Now that means any time through these sessions, if you'd like to raise a question, please do so. Alternatively, jot down the question and maybe raise it through Moodle or email at a later time. But I just want to talk firstly about the study of law, only briefly, as if you were a law student. Now, there is, and this might be difficult for those of you that are scientists, it's fairly difficult to say that this is the law. There is no such thing as the law. The practice of law, the way in which the law is written and operates, it's quite fluid, and in some ways it's cyclical. What I mean by that is this. There are, and you'd be aware in law, the separation of powers between the Parliament, which makes the laws, the executive, which administers the laws and executes the laws, and finally the judiciary, which interprets the laws. And in many ways, those three work in cycles, and they work in conjunction with each other. And you'll see that very often in your study of environmental law in Australia. But generally speaking, we start with Parliament. Parliament makes the laws, it creates the laws. But having done that and made a statute, then the parties which are involved in a legal dispute come to, they don't always agree on the interpretation. Lawyers disagree with the interpretation, and disputes then proceed to court. The court then interprets the laws, and even then judges will disagree. You'll have decisions of courts which are then appealed, and in the appeal courts there might be split decisions. So it's very hard for anyone categorically to say this is the law in any given circumstance. Once the decision is made by the Parliament, the community and Parliament then react, which then brings us back to the start of the cycle where Parliament then creates new laws, which is where I started with. Parliament makes the laws, we have policy disputes, we have disagreements, we have an election, and then we have a new Parliament which repeals the law, and we have new laws, and we start the cycle again. And that's particularly relevant in environmental law because it's such an emotive and, in a way, volatile subject that we are used to now seeing Parliament make laws, those laws be the subject of disputes and dealt with through the court system. So law is constantly changing, and it's probably better if I describe the practice of law as the practice of studying a legal process. So it's a bit different to a scientific type regime or an accounting regime that you might have been otherwise used to in your studies. I guess what I'm really saying in essence is, and treat this as an advantage rather than a disadvantage, there is not necessarily a right or wrong answer. So in writing an answer for a law question, it's really a question of whether you've identified the correct issues, whether you've identified the correct law, and then whether you've made a logical argument in relation to those about the legal principles that's important. The end result, whether a person is guilty, not guilty, or whether the company is liable, not liable, etc., isn't as important as the process that you've used to describe how you got there. So I hope you can understand that it's not a case of necessarily having all the answers or all the marks allocated because you got the right answer. Now, it follows from that you probably need to be careful of a simplistic answer. Paralegals, who I have a great deal of respect for, do, however, sometimes think in terms of black and white terms. This is the answer, it's X. Whereas sometimes the more senior the lawyer, the more experienced the lawyer, the more likely the lawyer is to talk in terms of alternatives or different scenarios for different circumstances. So there is a difference between also black letter law and equity. And you'll hear about these principles sometimes as we progress. Hi, Laurie, I wonder if I could just ask you to pop your microphone on there, to put your microphone off. We're just getting a bit of background noise coming through.
Oh, okay. Sorry.
Is that all right? Can you try and find that button to mute the microphone? Thanks, Laurie. And having said that, please come in and ask any questions at any time.
Okay, John, I'm going to ask a question, and it relates to a little bit earlier.
Okay. That's Nicole, is it?
When a statute, it is. Hi all. When I guess, and this is going to be really basic, so an act is created, and then you have a statute. Is a statute just a better explanation of a more detailed explanation of what's in an act?
Ah, good question. No, when lawyers talk about an act, which is with a capital A, and a statute, we're talking about the same thing. So, for example, if we talk about the Sustainable Planning Act, that is a statute. It's also an act of Parliament. So it's the same, it's different ways of describing the same thing. Does that answer your question, Nicole?
Yes, it does. Thank you very much.
But thank you for asking that question, and I encourage others to do so as well. So please don't be shy. Now, I mentioned briefly a difference between black letter law and equity. We might touch upon that later, but if you come across discussions about a legal principle versus an equitable principle, there's a difference in law between law and equity. I know it's all a bit hazy at this stage, but that really comes through when we talk about some remedies. So if a remedy in a court action is that you want to obtain some money, then that's a legal remedy. But if you want to stop someone from doing something, perhaps through an injunction, that's what we call an equitable remedy. Now, I won't go into the whole history of law, but just very briefly, back in the Middle Ages, the black letter law was supplemented by an entirely different jurisdiction, which was based on fairness, and it didn't matter what the statute said. It was where a fair result was determined. We call that equity. And eventually those two branches of law fused into the one area. So, but we still have this archaic distinction between legal remedies and equitable remedies. Anyway, I'll leave it at that for the moment. Now, any other questions before I move on? Just briefly, I don't know if any of you are planning to practice as a lawyer, but if you do, there is considerable advantage in having a specialisation in practice. That's particularly relevant in environmental law, and we have, of course, the Planning and Environment Court, and we have many practitioners who practice exclusively in that court, and they may come from a scientific background, for example, and sometimes having that other discipline which you bring into the practice of law provides you with considerable advantages over other practitioners in law who come from a purely legal background, and more so if they come from a general legal background. All right, now this course, I've mentioned that I'll be relying upon that text, environmental law, very heavily, but there are some others that you might want to consider. There's the publication by Philippa England, Sustainable Planning in Queensland. That's excellent. If you're really involved in litigation, there's the Community Litigants Handbook, which is quite a cheap publication, about $40, and it's produced by the Environmental Defenders Office. The author is Anita O'Hart. And finally, I'd commend to you Environmental Law, LexisNexis Case Summaries by Brad Jessup. Online, the resources are, well, firstly, the study guide modules by Dr. Lawson Smith, which you'll find on Moodle. AUSTLI, now that's AUSTLII. That's a really important one, AUSTLI. And then, of course, more familiar names, perhaps LexisNexis and Thomson Reuters. But I'll just stop there when I talk about the other resources.
Excuse me, can you hear
me? Yes, Laurie.
Yeah, I did a course last semester, and the lecturer told me that OSCE was not very reliable. It's not an authority.
It's not authorised, no, but I love it.
Okay.
But you're right. No, that lecturer was correct. If you want to go to the authorised area, you need to go to the Queensland parliamentary website. That's easily accessed through courts and Queensland Parliament. But I don't know. I just go to OSCE. I know it's not authorised, but it's extremely useful. And I think it would be a rare instance where OSCE can't be relied upon categorically. So I give it a big tick. You may prefer the authorised publications online instead, but I think OSCE is the way to go. But no, thank you, Laurie. Now, can I just mention about the study guides by Dr. Lawson Smith? I'll give you an exam tip right from the start. If you know your textbook and you have a good working knowledge of the statutes that are relevant to this area of practice, and I guess I'm really talking about the Sustainable Planning Act and the Environment Protection and Biodiversity Conservation Act, which is the Commonwealth Act, then that's probably all you need. So I think the textbook and the legislation. If you want bonus points, then you can look at other material. Certainly you can look at LexisNexis, but a lot of that is written by Jerry Bates anyway, so it's in the textbook. And you can look at Dr. Lawson Smith's notes. Now, Dr. Smith has prepared excellent notes, but they are of quite a theoretical, written from a theoretical perspective, whereas I'm very keen for you to have much more of a general working knowledge rather than a theoretical knowledge. And that's just the way, that's the focus that I'll be having on this. Now, so that's my exam tip right from the start. Are there any questions about what I've just said? Okay. And don't forget, if you don't want to talk, you can use the chat function too. You know, who was that? Sorry.
Sorry.
Yes,
Do you
Laura.
know do you know what was the second act you said? I couldn't get it.
Oh, sorry. The Environment Protection and Biodiversity Conservation Act.
Conservation.
Yep.
Okay.
It's 1999. It's the Commonwealth legislation.
Thank you.
All right. Now, tonight will be a relatively short session. I do try to make the sessions no more than an hour. Sometimes I'm successful. Most times I'm not. I'm sorry. But Chapter 1, Bates. I'm going to make this session so you can actually follow along in the text if you want to. I'll add some quotes from the text and I'll add some commentary. Bates says that the development of environmental law in Australia has been concentrated effectively into the last 40 years. And that's certainly true. When I was studying, there was no such thing as environmental law. It just didn't exist. So what we're learning here is extraordinarily recent. And it's also an area of practice that is growing extraordinarily quickly. Number of reasons for that. When one thinks about policy and politics, I guess it's easy to conclude that the most important things that relate to politics tend to be things like health, education, justice, and the environment. So these are really big issues politically, and because they are, and because they tend to be emotive in many ways, there is a lot of policy. And once we start to have policy, we then start to have legislation which is drawn to enforce or to enact that policy. And hence we have this mushrooming effect in terms of environmental legislation. At 1.3, Bates says environmental law is mainly a product of legislation. And that's true. Now, I will just digress here for a moment and talk in terms of what is the law again, if I can say what the law is. Firstly, we have statutes, which is also known as acts, ACTS, capital A. Thank you, Nicole. and that's prepared by both parliaments. So the two acts that I've referred you to that I really want you to know are the Sustainable Planning Act, which is Queensland Parliament, and the Environment Protection and Biodiversity Conservation Act, which is Commonwealth. So they're acts of Parliament, and they are effectively putting policy into law. Then we have what's called the common law, and the common law is judge-made law. So they're the two main areas of law, and I just wanted to give you some idea of the difference between legislation versus common law. Environmental law is really law in relation to regulating process. It's all about making sure that impacts on the natural environment are identified and taken into account in decision making, and that's from Bates. Therefore, I conclude from that that environmental law is largely based around administrative law. I'll just digress for a moment and say that because there was no such thing as environmental law 40 years ago, and it wasn't studied, it wasn't taught at universities and it wasn't studied as such, that doesn't mean that it doesn't have a long background in different ways, in different branches of law. And in many ways, environmental law draws its content from other branches of law, such as corporations law, companies, criminal law, in terms of prosecutions, and we'll touch upon that as well. That's both at state and federal level. Torts law. Now, torts is T-O-R-T-S. And if you haven't practiced in law or you haven't studied law, that may seem an odd word, but torts is all about civil wrongs as opposed to criminal wrongs. So back in the 70s when I was studying law, I would learn about the law of nuisance, which is a tort, or the law of negligence, which is a tort. These are actions involving civil wrongs. So environmental law draws upon torts law as well. It draws upon contract law, real property law, constitutional law. I've already raised administrative law. It touches on civil procedure, international law, alternate dispute resolution, and legal ethics. So even though it's one subject, it incorporates aspects of maybe a dozen other legal subjects. So for us to get through this course, there's an awful lot of law that we need to touch upon. At 113, Bates makes the comment, the environmental movement must rank as one of the great social revolutions of history. In most countries, the responsibility for environmental degradation was laid squarely at the feet of industry. Manufacturing concerns had treated air and water as a sort of natural conveyor belt to carry away all kinds of harmful effluents, which could have been disposed of in less convenient or more expensive ways. But prior to the environmental revolution, there was no pressure on them to do otherwise. The reason I raise that issue is that it is as a result of political pressure, which leads to the enactment of legislation, and from that, the litigation cycle begins, because that legislation is then interpreted by the executive and then ultimately reviewed by the judiciary. Now, I hope I haven't confused everyone totally at this stage. Any questions there? All right. If I could now touch on the legal system.
Can I just ask a quick question?
Yes, Jennifer.
Is the Commonwealth law same as the federal law? Commonwealth, you mean federal? Is it the same?
Oh, yes. Commonwealth means federal. Yes.
Yeah.
Thank you. Any other questions there? All right. Thank you.
Sorry, John, just one.
Yes, Nicole.
With the Commonwealth, and so that's separate to state law.
Yes.
So the ECPB Act is federal. Is the Sustainable Planning Act state, or is that federal as well?
No, it's state.
It's a state act.
State,
okay.
yeah. So I've selected one state and one federal act for you.
So which one, does one overrule the other?
Oh,
Or is it because they're in two different fields? But there's, I suspect there's crossover there.
There's certainly crossover. Where a Commonwealth or federal legislation conflicts with state legislation, the Commonwealth does prevail. That's section 109, I think, of the Constitution. But they do work in different fields.
Okay. Thank you.
Thank you.
Excuse me, John.
Yes.
Just the notes on the bottom. The notes on the bottom of the text, on the very bottom of the page, they seem to be sequentially numbered. But how do they reference back to that particular section of article that you're reading?
Sorry, what was that? Oh, the notes in the book.
Yeah. On the very bottom page of each page, there seem to be a sequential numbered series of notes.
Are you looking at my notes?
No, in the actual text in Bates's book.
In Bates's book?
Yeah. Right at the very bottom of the page.
John, it's referencing. It's the referencing. We've never encountered that before. We've only dealt with Harvard referencing.
Yes. I think you raised that in discussions today, Nicole.
I did indeed.
Thank you. Look, I think it'd be great if we could resolve this. Don, you're looking at Bates now, are you?
Yeah.
All right. Can you go to a page?
Right. Page 20. Say page 20.
Yep.
Right down the bottom, it's got 68.
Yep.
Ryan, should we, revising the 70s environmental law challenge in New South Wales?
Yes.
So how does that relate back to 1.36?
Okay. Well, certainly Nicole is right. That is an example of referencing. That's the type of legal referencing that we use. I must confess I'm not familiar with Harvard referencing, so I don't know, I can't explain the difference. But all the author has done there is said, when quoting Ryan, has made a reference of the source. So Ryan made that comment in that particular journal article in 2001. So in quoting Ryan or referring to Ryan, what's that? Sorry, Don?
Ryan is the author.
Yes, that's it.
Yeah.
Yep.
Okay.
In that particular journal. But look, for those of you who are a bit puzzled about legal referencing, once again, I'd refer you to the book, and just you'll get a feel for the way that the author has very well referenced documents. And you'll see the way cases, for example, are written. Even little things like they're in italics. And you'd wonder why that is the case. But let's see, in chapter 1, have you seen that?
John, just on that one point, so you've read, when you're reading 1.36 on page 20,
yeah,
is that taken from Ryan's original transcript, or is Ryan's an example of the transcript that's being written?
Right. Certainly, the way I read it is that the author Bates is saying that Ryan is one author who has espoused a certain warning. It's not a direct quote, but in relation to the proposition that we cannot measure success in terms of volumes of legislation, etc., Bates is quoting Ryan as authority for that proposition. Not quoting Ryan, but referencing Ryan as the source or a source for the proposition that the author is making.
Yeah, gotcha. That's all right. Yeah, no, all nice and clear. I just wanted to make sure I'm on the right track.
All right.
Can I just ask a question?
Yes, Laurie.
When you write in essays, when you paraphrase, is that like writing word for word, or is paraphrasing just making your own summaries? Or
exactly, paraphrasing is certainly not writing word for word. If you write word for word, that's a quote or a direct transcript. But paraphrasing is re-describing or describing in your own words what the author is saying. Now, there's a very fine line as to when you should reference, when you're paraphrasing, and when you need not reference. The general rule is that you want to be on the safe side. So, for example, it would have been very easy for Jerry Bates to have said, we cannot measure success in terms of volumes of legislation, prosecutions undertaken or orders issued. And without having acknowledged the work of Ryan, the reader would have believed that Bates was making that proposition from his own independent thinking. But being cautious, perhaps overly cautious, arguably, Bates has referenced Ryan as authority for that proposition, even though Bates has not quoted from Ryan. Does that answer your question, Laurie? And there's nothing at all wrong with referencing, even when you paraphrase. It's the way to go. It adds authority to your statements.
But then what happens if you get the wrong meaning when you paraphrase? You know, like you get the wrong idea of
that can happen. Yeah, that's a risk. I'm not sure I have an answer to that, other than don't get it wrong. Any questions there? All right. Look, I just want to talk about the legal system briefly. We do have, of course, the Planning and Environment Court, which is a specialist court. Family Court's another specialist court. Family Court is federal. Planning and Environment Court is state. It's at district court level. In Queensland, we have the Supreme Court as the highest level, the District Court below that. They're both presided over by judges. Below that, we have the Magistrates Court, presided by magistrates, and below that we have QCAT, presided by members. Although there is a Supreme Court judge and a District Court judge, or a number of District Court judges presiding in QCAT as well. So with the specialist courts, we have this movement towards specialist lawyers who practice in those areas. And I have spoken to a QC who I hope will be able to come along and address you as a guest speaker at some stage during the course to give you some idea of how the Planning and Environment Court works. There are some things that you need to be aware of, and Bates refers to this at 1.25. The criminal burden of proof is beyond reasonable doubt. In civil cases, there's a lower standard, which is on the balance of probabilities, and that contrasts with the scientific criteria of probability, which is based on a 95% confidence level in an animal or human study. So again, my comments are really directed for those of you who are of a scientific background. When something needs to be established in a court, you need to think about what type of court we're dealing with. And the big distinction there is criminal proceedings versus civil proceedings. If someone is to be found guilty of a crime, then prosecution must establish its case beyond reasonable doubt. You've probably heard that term before. However, if we're talking about a civil case, it's what's more likely than not is the relevant test. So if someone is suing on a civil debt or a civil action, they just have to prove that it's more likely than not, as opposed to beyond all reasonable doubt. What that means then is that if, as a scientist, for example, you're giving evidence in a court as an expert, in a criminal sense, it may be that your evidence is rejected. However, in a civil sense, your evidence may be accepted because of those different burdens of proof. 50-50 versus beyond any doubt at all, which is reasonable. Could I just also make comment about ADR? I mentioned briefly that alternative, whichever one you want, dispute resolution is an area of practice in its own right. It's relevant to environmental law because there is a push in environmental law to send parties to alternate dispute resolution to save costs, particularly in merits appeals. ADR is mostly recognised through mediation, but there is also conciliation and arbitration and other forms of ADR, or alternative dispute resolution. And my final comment before inviting any questions for tonight is at 1.32, Bates makes reference to this quote: "A further barrier to the involvement of more lawyers is the restrictive code of legal ethics, which recognises only a duty to the client and the court." Now when I read that, it really rang true, because in the practice of law, while we do have a duty to the client, the only thing that overrides that is the duty to the court. In other words, we can't mislead the court. We have a duty as a judicial officer not to do that. But ensuring that we don't breach that duty to the court, our only duty is to the client. What that means is, as lawyers practicing in environmental law, we don't have a duty to the environment, we don't have a duty to the public generally, and that therefore means that in environmental law there may be some problems associated with the way in which the court cases are structured and conducted. The counterpart that I can think of is in relation to, let's say, child protection proceedings, so that if a lawyer is representing a parent where an application is made for the child to be taken from that parent's care, the court has the power and will very often appoint a lawyer to represent the interests of the children. Now, it occurred to me that we could probably look at something like that for environmental law, where a court might appoint a lawyer to specifically represent the interests of the general public in terms of the environment generally. It hasn't happened yet, but it occurred to me that that's the sort of thing that may occur in the future. All right. Now, I'm not sure if I promised you a short session today, but there it is. That's all I propose to talk about from Chapter 1 of Bates. But I do hope that you've all read it yourselves, and as a result, there may be some things that people think are worthy of comment that I haven't touched upon. If so, and if you'd like to share it, please do so. Now, you can use the chat facility as well. And I saw your note there, Don, in relation to the notes at the bottom of the page from earlier, so thank you for that.
Okay, John, I am going to say a couple of things.
Yes, Nicole, that's fine.
I actually found it fairly chewy, the whole, I mean, I read ahead on a couple of chapters because the subject actually does worry me, I have to admit, because I find it a very foreign concept. With the, because you're discussing the exam questions earlier, should we get copies of those acts and actually spend some time reading over them?
The answer is yes, but do it selectively, do it carefully. Look, part of what I'm trying to do tonight is just reassure you that even though this is a very meaty subject, and in some ways a very difficult subject, we're not going to make it insurmountable. We're going to make it bite-sized, we're going to make it comfortable and interesting, and I'll probably use this word fun a bit, because I do want you to have fun with it. It's an area that it's so easy to become interested in this topic that I'd like to think that Bates becomes a bit of a page turner for you. You can't wait to get to the next sentence or the next chapter, because it is highly readable and it's very interesting, it's very topical. So I hope that we can sort of work towards that. The other thing that I'm trying to do is reassure you that the exam isn't going to be based on theoretical, esoterical material. I don't want you to be reading too widely on this. There's already enough material there to cope. and you may have to read it a few times. Sometimes I think it's a good idea to almost speed read the first time through, just to get a general feel for it. You know, if you're confronted by a chapter of 50 pages, you know, you don't want to get bogged down on the first half page, if you know what I mean. But just let it go over your head a little bit. Go through. I'm a big fan of highlighters and tabs. You can probably see my book full of pink tabs already, and lots of highlighting all the way through. So, you know, I'd recommend you do that. That's going to make it easier for you for the exam as well. Now, Don has said, can I post the act? Oh, yes. With the legislation, don't go out and buy it. If you go to Austly, sorry, Laurie, if you go to Austly, and I'll repeat that again, it's AUSTLII, you'll find the acts. What I'll do is I'll see if I can create a link, and I'll give you a link on Moodle to those acts. Now, particularly with the Commonwealth legislation, it'll drive you crazy if you try and read it all. But just read it selectively. Probably you can read it in reference to Bates. So if you see a piece of legislation referred to in Bates, and you want to read that, then you can go through Austly to the legislation. Now, it doesn't have to be just the two acts I've said. You might want to, you know, you might read something about the Civil Liability Act in the material, or the Coastal Protection Act, and you might think, well, that's interesting, so you can go to Austly and do that. Has anyone used Austly yet, or no one's used it? All right. Okay.
My 18-year-old daughter introduced me to it.
Oh, did she? Okay.
Yes.
I'll try. I'll bear that in mind. I've got to remember, I'm not talking to law students, and that's not meant to be a criticism at all. But just, I have to make sure that I don't fall into the trap of assuming that you know things that that you wouldn't have had reason to consider before. So I'll keep that in mind. So don't be daunted, Nicole. But thank you very much for your comments, and I'll make a note to post legislation. Any other questions?
Yeah, I have a couple, mate.
Yes, Boris? Spiro, sorry.
Yeah, right. The exam that we'll be doing, obviously I look at the old ones and they're open book.
Yes.
You know, is that the general process for this one as well?
Exactly. I won't be departing too much from that formula. That's another exam hint. It'll I think the exam from memory was last year was 5 out of 7. I think they might have been worth 10 marks each. It'll be something very similar to that.
Okay, no worries.
There won't be too many surprises.
Earlier, okay, great. That assessment 1, the first part where we look at the planning and environment course.
Yes.
You talked before about there's either criminal proceedings or civil proceedings. Which does this fall into? It's, you know, it
civil.
sort of sit in either.
Yeah. Well, sometimes they can blur, but have a read of it, and look, share some thoughts, if you don't mind, on Moodle. Can I just give you this thing? I'm not going to mark, if I see that you're sharing your thoughts on Moodle and you're engaging with other students in an interactive discussion, I'll read that, and how can I say that? You're going to get some credit. You're going to get some credit for being proactive and being willing to share. Now, I can't really say any more than that, but I guess what I'm really saying is, put your thoughts down in the discussion through Moodle. I'll monitor all that. If I think someone's going offline or way wrong, I'll come in and correct it. But I think it's really worthwhile having some open discussions about it. So if you think that it's the case has a criminal law flavour to it, Spiro, please make that comment and see what other students say.
Okay.
Thank you. Was there another question or comment?
Yeah, I do.
Yes.
I was just wondering, are you happy for us to like send our work over to like a printing company and print out the legislation, print out your study notes, save our ink, or
So,
are you happy for?
so what was it? What do you want to do, Laurie? You want to send it off to a printing company?
Yeah, printing company and have them print off the study guides or the notes.
Do you mean the notes by Dr. Lawson Smith, the study
No.
modules?
No, your study guides.
Oh, I see.
Study.
I'm not sure I do have any study guides as such. Sorry.
Oh, okay. Okay.
Mine are just mostly based around the legislation. Sorry, the textbook.
Oh, okay. Thank you.
Thanks, Laurie. No, you're right. I'll have some one day, but not now. Thank you. Now, any other questions? Okay, nobody's put anything new on the chat forum. Well, that being the case, I might look to wrap it up. Thank you very much for your attendance. I hope that you're enjoying the course so far. I encourage you to keep ahead with your reading. Just 1 week is fine. And if you have any questions, please feel free to raise them through the general discussion or bring them along to our online sessions, which generally will be Tuesdays at 5:30. So unless there are any closing questions. Yeah,
John,
sorry.
just one there. I don't know whether other people have experienced it yet, but with the textbooks, there seems to be quite a bit of delay in getting them. Like it's over a week and a half, and mine only arrived last night. So I don't know whether everyone even might not all have their textbooks yet, but there seems to be a big delay in sending them out this year for some reason.
I have noticed that a few students have made that comment. So
yeah.
I'm hoping that they're filtering through pretty quickly now. But thank you, Don.
Yeah, no worries. Okay. Thank you.
All right. Well, thank you very much all for your participation. I'll stop recording. I'll end the meeting now, and we'll speak to you soon. Bye.